let's talk about the Nevada court system. Practicing in Nevada courts is in many ways very similar to practicing in federal courts. In fact, most of Nevada's civil procedure rules are modeled directly after the federal versions. So, in the end, a motion for summary judgment in many ways is going to look the same whether you're in a Nevada state court or a federal court. But there are some important differences in how the Nevada court system is structured and how it works. Nevada courts include the Nevada Supreme Court, the Appeals Court, the District Courts, which include family courts, the Justice Courts, the Municipal Courts, and finally, certain specialty courts. Let's talk a little bit about each. The Supreme Court is Nevada's highest court. It is composed of a Chief Justice and 6 Associate Justices. The Supreme Court decides cases in panels of 3 justices generally. The full court must consider any case in which 2 members of a panel make such a request. Below the Supreme Court is the Intermediate Court of Appeals. Nevada's Intermediate Court of Appeals is relatively rare in that it is a so-called top-down system. In most states, virtually all appeals from the trial court go directly to the Intermediate Appeals Court. Then, if a party loses at the intermediate level, it must petition the state Supreme Court to request review. But in Nevada, all appeals from the trial court go directly up to the Supreme Court level. The Nevada Supreme Court then decides whether to transfer the case to the Intermediate Court or to retain jurisdiction and hear the case themselves. The Nevada rules set out an appeal scheme where certain types of cases are within the exclusive jurisdiction of the Supreme Court that can never be sent down to the Intermediate Appeals Court. The most important types of cases that can only be heard by the Supreme Court include death penalty cases, cases involving election issues, cases involving judicial misconduct, cases involving attorney misconduct, cases involving novel questions of law that have never been decided before, and cases involving disputes between different arms of the government. Generally, other types of cases are presumptively appropriate for the Intermediate Court, but the Supreme Court still has the ability to keep the case for itself. When appealing from the trial court, the appealing party in Nevada is required now to submit a statement explaining to the Supreme Court whether the case should be sent to the Intermediate Court or whether the Supreme Court should keep the case and decide it itself. Below the Intermediate Courts are the Nevada trial courts, called the District Courts. But the District Courts hear any cases that are not first sent to the Justice or Municipal Courts, so let's look at those first. Nevada's Justice Courts handle minor civil cases not exceeding $10,000 in damages, evictions, misdemeanors, small claims, traffic cases, and other similar, fairly minor matters. They also handle first appearances in criminal cases. The municipal courts handle violations of city ordinances, proceedings to stop a nuisance, actions for collection of city taxes of less than $2,500, and similar local small matters. Now, going back to the district courts hear all other cases that are not handled by either the justice or municipal courts. Thus, the district courts are the workhorse of the Nevada system. They handle all trial issues in civil and criminal cases. Nevada's district courts also have jurisdiction over juvenile justice. In Clark and Washoe County, the legislature has established the family courts, which are divisions of the district courts. So now looking at the structure of the district court system, there are 10 judicial districts in the state, which encompass all 17 counties. The legislature sets the numbers of judges that will serve in each district. The 2nd judicial district, up in Washoe County, and the 8th judicial district, down in Clark County, have the largest number of judges. Finally, there are the specialty courts. Specialty courts are problem-solving courts that address drug or alcohol addiction, problem gambling, juvenile delinquent behavior, or parental abuse or neglect of children. Currently, Nevada has a whopping 46 specialty court programs. Nevada also has a substantial alternative dispute resolution component. Every civil action filed for damages in the district, those trial courts, must be submitted to non-binding arbitration if the amount in issue does not exceed $50,000. Again, this is non-binding arbitration, so the parties don't have to agree to the result. The alternative is the parties can take part in settlement conferences, mediations, a short trial, or other alternative methods of resolving disputes. This should give you an overall idea of how the Nevada court system is structured and how it's different.